If you are someone who is present in the United States and you have an employer who wishes to petition for you for a green card, the process begins first by asking how you are present in the United States. You have to be maintaining lawful status in the United States in order to be able to get a green card inside of the United States. If you are someone who entered without inspection, unfortunately, you will not be eligible to get a green card through your employer because you will have to go through consular processing. That means that you'll have to leave the United States. And if you leave the United States, you may be barred for 3 years from returning if you were here unlawfully for 6 months or more, or you may be barred for 10 years if you were unlawfully present for 1 year or more. Now, the only way to apply for a waiver or be forgiven for this unlawful presence is to have a U.S. citizen or lawful permanent resident, spouse, or parent. But if that were the case, you would have been seeking adjustment through a family petition as opposed to an employer. This means that most people who are seeking a green card through employment don't have these avenues to begin with. So it's unlikely that you'll have a spouse or a parent who is a green card holder or a lawful permanent green card holder or a U.S. citizen that would make you eligible for a waiver of that unlawful presence. If you are someone who entered with a visa to the United States and you overstayed, we run into the same issue. You have not maintained lawful status in the United States. So again, you will be ineligible to receive a green card inside of the United States. But for example, let's say you're present in the United States under a student visa and you've maintained lawful status and you have a prospective employer who wants to go ahead and petition for you. Thereafter, it becomes discussing with the employer what position they envision you having in the United States, because we have to turn to the Department of Labor and provide a description of that position, and the Department of Labor will go ahead and give us a wage, a salary that must be paid for that position. Thereafter, we must go ahead and advertise for that position and provide evidence that there are no U.S. workers willing or able to do that job. So in that advertising process, we will go ahead and review candidates who are eligible for that position. They will be interviewed. If no one applies, then no one applied for the position and there are no U.S. workers willing to apply for that position. So once all candidates have been eliminated or no U.S. workers applied, we can proceed to the next step and apply for the labor certification. So once we go ahead and submit the labor certification and that is granted by the Department of Labor, we can turn to immigration, to USCIS, and submit the Form I-140 petition for alien worker. We can submit evidence that we went through the proper channels of recruitment, we were certified by the Department of Labor, and that the employer has taxes or other evidence to demonstrate that they have the ability to pay the wage that the Department of Labor has stated for that position. So once the I-140 is approved, then the person can proceed to applying either for a green card adjustment inside of the United States or consular processing if they are abroad.